Facebook. Bonnie.
All right, greetings everybody, and a very warm welcome to this pretty remarkable event. And I am going to begin by with a few housekeeping notes. Firstly, that this is going to be recorded. So by entering into this Zoom session, you have consented to the recording. It will also be live streamed on Facebook. And so feel free to tell your cohorts of friends, and please do leave messages on Facebook. We do ask you to please turn off your video, with the exceptions of the speakers, who of course will leave their videos on, but unless you're speaking, please do turn off your video. It helps with the bandwidth for all the people who are attending. And of course, please do mute please do mute yourself as we progress. I'm going to hand over to David Bulchitz, Professor Bulchitz, in a moment to welcome you on behalf of SAIFAC. But before I do, if I may welcome you on behalf of the Animal Law Reform South African group, which consists of the singularly spectacular Amy Wilson, who is really the oil that moves the cogs of the wheel of so much that has developed in animal law and animal welfare and animal rights, not only in South Africa, but worldwide, and who is also the oil that has smoothed the gyrations of organizing tonight, this afternoon, depending on the area you're from. So Animal Law Reform South Africa is a new organization. We're only a few years old, and yet I'm proud to say I have developed a body of work that is singularly groundbreaking, mostly due to Amy and David. Professor David Bulchitz is a longtime friend and certainly one of my closest colleagues, who will now be introducing SAIFAC and welcoming you from SAIFAC. I hand over to you, Dave.
Thank you very much to Bonnie, Professor Meyersfeld, for that introduction. I am welcoming you from the South African Institute. I'm the director of the South African Institute for Advanced Constitutional Public Human Rights and International Law, a very long name, which we call in short SAIFAC. SAIFAC seeks to promote engaged discussion around some of the most cutting-edge developments in our areas of focus. And one of these is actually the developments around the world in animal rights and expanding the notion of rights beyond the human species. And we actually, to that effect, I'm sure many of you know, we actually promoted a conference called Legal Evolution and the New Rights Revolution, expanding the sphere of protection to animals and the environment, which we had hoped already to have had, but sadly, because of the COVID-19 pandemic, that had to be put on hold, but we hope to reignite it. At the same time, we didn't want to stop our activities around these issues, and so we wanted to have perhaps this can be seen as a taster or of that conference, but also a strong event in its own right, with luminaries from across the world who've been engaged both in the trenches and as well as theoretically and conceptually in advancing the sphere of, we could say, of our compassion, the sphere of our justice towards other creatures. And so we're very much looking forward. Actually, one of the things that struck us was that much of this, many of the advances have taken place in relation to animals in captivity. And so we want to kind of look at that specifically, and which is one of the focal points for tonight's discussion. And so I'm very much looking forward to our discussion. As I said, and we're very happy to co-host with Animal Law Reform. I also hold a hat as a co-director with my wonderful colleagues there. And I also want to, as SAIFAC, also welcome those of you, many of you are interested in wider questions. So please join us for other seminars. Tomorrow we in fact have one on climate change at 12 o'clock South African time, 12 to 1:30, dealing with why people are unable to follow through on their behavioral changes, that even if they recognize the importance of something, which is actually a very important issue around questions around animals as well. So you're most welcome to join us tomorrow as well. If you want to, please also RSVP to Naomi. And thank you to Naomi, who I know is here as well, for all her organizational acumen in helping to get this off the ground, as well as to Amy. So without further ado, over to Bonnie. Bonnie, you're muted.
Thank you very much, everybody. What would a Zoom meeting be without a "you're muted" reminder? A warm welcome again. And now my video's off. A very warm welcome again. I really am delighted to have you all here. We are going to begin with a series of speakers, and I will introduce them shortly, but allow me first to begin with an apology, which is, as most of you, I'm working from home, and I do have a door that is open that might admit any number of species into the room at any one time, be it of the canine or the human category of various shapes and sizes. If that does happen, I do beg your indulgence and forgiveness. I hope otherwise that there will be no detraction from the professionalism of the event. Michael J. Fox once said that zoos are becoming facsimiles or perhaps caricatures of how animals once were in their natural habitat. If the right policies toward nature were pursued, we would not need zoos at all. There's so much in that quote that resonates with the reason why we're having this convening today. And that resonates with the developments that our extraordinary panelists have spearheaded, in which they've been involved, and really on their shoulders lies some of the greatest advances in relation to the liberation of animals from captivity. The speakers will present in the following order. We'll begin with Professor Stephen Owais. We'll then progress to Dr. Alok Hisarwala Gupta. We will then move to Owais. Oh, forgive me, sorry. We will then move to Macarena Montes. And finally, we will have Owais Awan. I'm going to tell you a little bit about each speaker as I present them, as they begin their presentation. So on that basis, I would like to now move to welcome and introduce Professor Stephen Owais. I met Stephen, I think it was about 110 years ago in a very different context, but it's always so wonderful to see you and such a privilege to have you with us. Stephen has spent the large part of the last, I need to do my maths, for a very long time, since 1985, working in the advancement of the rights and welfare of non-human animals. He holds a JD from Boston University Law School and a BS in chemistry from the College of William and Mary. As many people know, he has practiced animal protection law for over 4 decades and taught the first class in animal rights law at Harvard Law School and at Stanford Law School, as well as several other law schools, including animal rights jurisprudence at Lewis and Clark Law School. Probably most importantly, Steve wrote this seminal piece, Rattling the Cage Towards Legal Rights for Animals, the devastating piece on drawing the line, science in the case for animal rights. Though the heavens may fall, the landmark trial that led to the end of human slavery, as an American trilogy, Death, Slavery, and Dominion along the banks of the Cape Fear River. Stephen, above all, and what you won't find in his bio, is that he is equally humble as he is great. And he has dedicated his life not only to non-human animals, but also to the mentoring of young lawyers who work through this field. And I think that's an attribute of Steve that many don't know unless they have benefited from that fold. And Steve, it was with great admiration, affection, and gratitude for the work that you do that I hand over to you.
Well, thank you. Thank you very much. I just want to say, after Owais won the rights for Taiwan in Pakistan, I called him up and congratulated him and told him how aggravated I was the fact that on his very first case, he wins rights for his client and And I started trying before he was born, and I still haven't done as well as he has. So, but I still congratulate him. I think he's a wonderful guy. But I told him I was very envious. Anyway, the Non-Human Rights Project indeed began, at least the work of it began in 1985 or 1986. And then the Non-Human Rights Project itself started in 1995. And then it wasn't until 2007 that we began to really work hard to try to prepare the first litigation arguing that a non-human animal should have rights. And then it wasn't until 2013 that we actually filed those first lawsuits, and that was in the United States. So all of these years, 1985, what is it, 36 years, but more than 25 years, we had worked to try to figure out how we could deal with the serious problem of the fact that non-human animals everywhere, including the United States, were seen as legal things who lacked, every sort of right, and that the only entities who have rights generally are persons, and a person is an entity that might have one or might have more rights. So how would we be able to move at least some non-human animals from the category of things to the category of persons? We spent an awful lot of time trying to think about that, and we decided that we were going to begin, and we're still doing that right now, by focusing on the fundamental right to bodily liberty of a captive non-human animal who is an autonomous being. And so to support the autonomy, of our client, and we began to speak to the world's greatest scientific experts, on that species. So far, we've been litigating on behalf of chimpanzees and elephants. We'll still be doing that, and we'll be moving towards orcas likely in the next year or two as well. And we speak to these incredible scientific experts, and we ask, are they autonomous? And what kind of evidence is there? And if you think that they ought to have rights, and you sympathize with what we're doing, would you then write these affidavits that we can use to support our arguments that our client, so far a chimpanzee or an elephant, ought to have the right to bodily liberty through classic kinds of liberty or classic kinds of equality, that we can then have the court order them removed from the zoo or wherever zoo-like place they are, and then sent to a sanctuary, because they're usually not going to go into the wild. So, but our cause of action is actually common law habeas corpus. So we sue under the common law in an English-speaking country, and the reason we do that is we don't want to bring suits on behalf of statutes or on behalf of constitutions, because we really don't want judges to decide what the people who made the Constitution or the people who made the statute, what they had in mind. Did they imagine that a non-human animal might be under their habeas corpus statute or Constitution or liberty? So what we do is that we seek a common law writ of habeas corpus. Now, why have we, since 2013, have we always sought habeas corpus? And then we noticed that many folks who are bringing cases in other states also oftentimes use habeas corpus. Well, the reason we do is it's called the Great Writ, and that means that judges may take our case more seriously, especially in light of what our experts are showing, how cognitively complex and autonomous our clients are. So it's a great writ for human beings because of who human beings are, and we are essentially arguing that it's great for our client too. It should be a great writ for them. Second thing is that third-party standing is generally permissible in habeas corpus cases. So if we were bringing a non-habeas corpus cases, we'd have to somehow show that we were able to bring the lawsuit on behalf of our client. But habeas corpus cases are used to the fact that someone is in jail somewhere, or someone is being kept against their will somewhere, and they can't come in, but a third party can, and we argue to the courts that we can, and we generally win that. The next thing is res judicata generally does not apply to habeas corpus cases. So if you bring legal cases, if we can bring any kind of legal case that we lose, then we can't bring that case again, because the judge will automatically say, as a matter of defense, when the other side will say, they already lost, there's res judicata, they can't bring it again. The thing about habeas corpus is that unlike almost every kind of cause of action, judges everywhere in habeas corpus, while they don't have to allow a case to be brought again, they generally have the option of doing that. And sometimes they've used it, oftentimes they haven't. Also, habeas corpus is a summary writ. So that means it goes really fast. And our cases will generally move very fast. And that means that they're cheap. Also, it means that we don't really care that much about what trial courts do, for us, because we generally assume we're going to lose in the trial courts. We don't want to litigate a case for 2 or 3 years to go up to an appellate court. If we're going to lose, we'd like to lose immediately so we can move up to where we really want to be, which are the high courts of our jurisdiction. Habeas corpus also permits a common law sort of flexibility. And also there usually isn't a requirement that we exhaust any kind of administrative remedies. Also, there's usually habeas corpus, we can show at least twice, once in England in the Somerset case, once in the United States in the Standing Bear case, that habeas corpus cases have been used to actually make clear or establish the personhood of entities who had not been seen as persons, who didn't even have a right to habeas corpus. So far now, we have filed 6 cases in New York on behalf of chimpanzees, and 1 case in New York. Have I always?
I think we've lost
I have
you.
to start over?
No, just the last minute.
I'm so sorry. Let me make sure I don't do that. So we wanted to. Oh, I know. Okay, so I was saying we filed 6 cases in New York on behalf of chimpanzees, and 1 New York suit on behalf of elephants, and that brought us into 5 intermediate appellate courts, and we lost in all of them over the years. But we always figured that we would, and that's one of the reasons why we wanted to get out of the trial courts and begin to make our arguments in the appellate courts. So, why did we lose? Why do we expect to lose these cases, these habeas corpus cases, seeking, the end of our clients being held somewhere against their will? Well, I think we understood that judges had never heard of this before. So in 2013, while they've heard of it now, many places, they hadn't heard of it then. And that a lot of them were going to simply be aggravated with us, or think that we're not worth anything, and they just wanted to get us out of the way. And some of them just didn't like the idea. They didn't like non-human animals, the idea of them having rights is something that they didn't like, or they occasionally were based on gross misunderstandings of what the law was. It was interesting that oftentimes in our trial courts, even though we would lose, many of the trial courts were actually quite favorable to us, but felt that they were bound by the law, and there's no way that we could win. Now, in New York, you have trial courts, then you have a level of intermediate appellate courts, then you have a single high court, which is the New York Court of Appeals. So there are 4 intermediate appellate courts in the state of New York. The first intermediate appellate court, who issued a decision and issued the really interesting one, when we sought an appeal, they simply decided on their own that we didn't have a right to appeal, so they simply dismissed our case and said, we don't even want to hear it because you don't have a right to appeal. They, of course, were wrong, and no court has ever done that since, but that's how the very first appellate court in New York tried to deal with our appeal, by saying we didn't have a right to appeal for reasons that no one ever understood. The second time we went to an appellate court was actually much more complex and still has problems that we're dealing with in the state of New York and elsewhere. That was the so-called Lavery case. And what they claimed was that, well, there were basically like 2 things. They claimed that US law was grounded upon something that they called social contract, which gives legal rights only to entities able to bear bear them, but to entitle, you had to be able, in order to have any right, you had to be able to bear rights and duties. In other words, having the ability to bear right was not enough. We had to then show that our client was able to bear duties, and they'd say, well, your chimpanzee can't bear duties even if they could bear rights, therefore you lose. But only those kind of entities could be persons. This was entirely wrong. They simply had no idea what they were talking about, but that has turned out to be a dangerous case for us. One of the things that was done was based on the writings of an obscure writer named Richard Cupp, whoever he is, and when we actually attack what he said, we actually refer to them. I'll quote you a sentence we did in our last brief, which we said he engaged in quote, junk political science, junk philosophy, and junk history, unquote, which is exactly what he did. Since then, we've had numerous philosophers and others file amicus briefs in which they try to explain to courts that the idea that he had, that you have to be able to bear rights and duties in order to be persons, is not social contract. It's actually the opposite of social contract, because obviously only persons can enter into a social contract, and so it makes no sense to say social contract creates persons. Another really strange thing happened to us, as many strange things have done, is that the court actually read something which in the United States is very important, called the Black's Law Dictionary, which said you had to be, in order to have a right, you had to be able to have the capacity for rights and duties. After we saw that, we actually went to Black's Law Dictionary and realized that it had made a mistake. We then wrote an email to the editor-in-chief of Black's and said, you got it wrong, and you're hereby screwing up our case because you got it wrong. You said you had to be able to have the capacity for rights and duties, and the quote that you made was from someone who said you have to have the capacity for rights or duties. Would you do us a favor and change the Black's Law Dictionary to what it ought to be? They said they would, but it took them 3 years for them to actually come out. And meanwhile, that didn't really particularly help us. Now, the third appellate court just made a silly mistake. They actually seemed somewhat in favor of chimpanzees, but they simply got confused about what happens when a prisoner, whether they're a human prisoner or a chimpanzee prisoner, wants to move from their jail to someplace else. They thought you couldn't do it, when the New York case law said you could do it. A judge now of the New York Court of Appeals has pointed out to them that they were indeed wrong. And the fourth appellate court, who we lost in front of, said, look, only humans can have rights, period. We don't care about anything about chimpanzees. Only humans can have rights. Plus, they threw in the argument that, we don't think we should talk about this. We think courts shouldn't be dealing with such an important issue, that they should go to the common law. So we had, we tried to go to the High Court of New York. That's where we really wanted to be, which is the New York Court of Appeals, which is a very respected court. Every time we would try to go to them, let's see, the first time and the second time, they simply said, no, we're not going to hear your case, and that was the end. So that's why we bring another case. So we decided to bring a third case. We decided to bring cases until the animals in New York ran out. We were just going to keep bringing it and demand that we go to the Court of Appeals. In 2018, that was the third time we actually brought a case. And that time, the Court of Appeals, for the third time, also refused to hear our case. But this time, something unusual occurred. A judge named Eugene Fahey wrote an opinion in which he said that he had voted against us twice, but that he'd been thinking for the previous 3 years about what we had done, and he had changed his mind. And one of the things that we always believed was that there's some smart judges up there who may have never have thought of the kinds of arguments that we're making. But if we can continue to bring the cases, and again, that's the reason we use a cause of action that doesn't use res judicata. We thought we're going to have to bring the same case again and again and again and again. So on the third time we went up to this judge, Judge Fahey agreed, said that he'd been thinking about it, and he essentially changed his mind. And he explained in great detail why he thought that we were right, and ended up by saying that chimpanzees, were not things. They were likely persons, and they were not things. So, fine. That caused us to file our fourth one. Now, the fourth one was the first one we had involving an elephant. And that's one of the reasons is that we'd used up all the chimpanzees. We couldn't find any. There weren't any more we could sue on behalf of. So we decided to use our second non-human animal, which was an elephant. And so we did that. And the first time we did that, actually, a Supreme Court judge, which is actually in New York, is a lower court judge, issued the writ of habeas corpus for the first time. And then sent the case to another judge in the Bronx. Now, we sued Happy, who was actually owned and brutalized by the Bronx Zoo, and had been that way for more than 40 years. So we weren't sure that we were all that happy about being sent to the Bronx. We wanted to go somewhere else, but there we were. And this is where something really important happened. The judge in the Bronx was extraordinary, because one of the things that we had always encountered were judges who would hear us for 15 minutes or 30 minutes. I think one judge heard us for 45 minutes. And then oftentimes they would rule against us. This judge allowed us to argue for 13 hours. She allowed 13 hours of argument over 3 days. And that was the first time in which we could always make it really clear what our legal arguments are, make it really clear what our factual arguments were. She wrote an extraordinary opinion in the Happy case, in which she, all the way up to the end, in which she explained essentially why we should win. She agreed with Judge Fahey. She said they had dignity, they should freedom, they should be a person, but she still felt that she was bound by that higher court, who had relied on Cupp, who had no idea what he was talking about, and Black's Law Dictionary, which had by then admitted it was wrong. So we said, fine. And this time we went to the first department, and the first department was that court that had last time we were in front of them had said a non-human animal can't have a right because they aren't human. They were so interested in the argument that I'd made for 13 hours that they then sent me in a notice that they would allow me to argue for 6 minutes. And you can't imagine how little I was able to talk about in 6 minutes. And if you ever want to see it, you can watch me in my biggest fight I can make in 6 minutes. And I finally ended by saying that to this one judge, trying to nicely tell her that she didn't understand what I was saying. And so then they wrote a 1-paragraph opinion saying, just get out of here, you lose, for the same reasons. We said, okay, up we went to the New York Court of Appeals. And 3 weeks ago today, the New York Court of Appeals, the 4th time we tried it, said that they would hear our case. And in that time, it only took 8 years. We were only in front of like 40 judges. We were in front of 8 courts, 9 courts. But we were finally able to do that. And our brief is due in about a month. And it's the highest court of any jurisdiction that is a common law jurisdiction. It's a really important case. Whether we win or whether we lose, it's still a really important case. And if we lose, well, if we win, we're delighted. If we lose, we hope we don't lose unanimously. We hope that there are dissents, who come our way. Perhaps even a case we can, one that we can even bring that would be a 5th case or the 6th time we try to go there. Then I just want to talk about quickly international stuff. The international cases, we have now been working.
Can you take another 5 minutes or so? Sorry to interrupt you.
Mine will take less than that. I'll try to talk faster. But I'll make it done quickly. Thank you. And those are, we've been working with, and I, when there's no COVID in the world, I tend to travel constantly throughout the world, speaking, teaching at law schools, speaking at conferences, talking to judges, talking to lawyers who do extraordinary jobs. So we've been working internationally for a very long time. But for example, and now we have a case that we are working with in India. We've been working on it now for 2 years, and we were about ready to file that case last month, but India is having a very hard time right now with COVID. So we're going to have to wait until things do better in COVID. But we have a case involving an elephant. We have one of the largest, most respected law firms in India is representing us and going to be helping us. And we already have the extraordinary lawyer there named Raj Panjwani, who won the Nagaraja case in 2014. When we go to the India Supreme Court, he'll be taking our case. We have another case we've been working on in Israel. We'll be filing the first case a habeas corpus case directly in the first in the Israeli Supreme Court, has to go directly there. Again, we were ready to file that lawsuit, but for a couple of reasons, including COVID and the other reasons that Israel's having, we don't think it's ready right now for us to file that suit, but we'll be doing that very soon. We filed an amicus brief in the Columbia Constitutional Court. We are now beginning to work with Harvard Law School to file a joint amicus brief in Ecuador. The Ecuador Constitutional Court is going to be dealing on the question of, number one, are primates subject to habeas corpus under Ecuador law? And also the question, are primates subject to rights because of the fact that Ecuador has a rights in nature part of their constitution? We're also talking to lawyers in Argentina, and we'll likely be filing a lawsuit on behalf of chimpanzees in Argentina. So we also note that other judges around the world sometimes mention our case. Sometimes they seem to think it went better than we did, but we're not sure they went as well as they think. But we still are happy that they are citing our case. So I don't want that. You're about to see some really extraordinary speakers. I don't want to take more time. So thank you very much.
Steve, thank you so much. And it was just so evocative of and evokes so many of the difficulties I think that lawyers are facing around the world when it comes to litigating on behalf of non-human animals. And one of those is fear on the part of the judiciary and decision makers, fear to actually step outside of the zone of comfort. Even though the law may be clear, even though the arguments may be clear, this is an aspect of the litigious process that is not about law. It's about human fear and about looking at a body of law as something that is not a parallel issue to humanity. It's in fact inclusive of issues relating to humanity. And our next speaker, Alok Hisarwala Gupta, is going to talk a little bit about, well, hopefully more than just a little bit, about some of the amazing work that's been going on for him in Bangalore. But what I do want to say about Alok when I introduce you is one of the phenomena I've experienced working in the world of animal well-being and lawyers advocating for animal well-being or rights or welfare on the one hand, and on the other hand, working in human rights law, is that human rights lawyers tend to not care about animals. And animal rights lawyers tend to not care about issues of human rights and equality. And slowly that's starting to move. And in Alok, we can see a person who is a lawyer, an activist, and a researcher, not only for one side of the spectrum being human issues, or one other side of the spectrum being issues relating to animals, but both. And so Alok has worked on matters relating to LGBTQI+ rights. He has practiced as a civil liberties lawyer in Bombay for over 10 years, written widely and participated in the decriminalization of homosexuality in India, in a context that really is unbelievably fraught and difficult. And as one can imagine, having to fight in a context of conservatism is one that takes an enormous amount of energy. Alok, I'm very glad to say, not only as a graduate of Bombay, but spent a semester at the best university in the world, the University of the Witwatersrand, at which I am an associate professor, and attained a master's in law from a university you may have heard of, I'm not sure, Columbia University in New York. And so not only that, but Alok has also worked as a research assistant for Justice Edwin Cameron and Justice Albie Sachs, who are both former justices of the South African Constitutional Court, both of whom embody a certain humanity to which I certainly can only aspire. But Edwin Cameron has recently become a vegetarian and wrote to me about the seminar saying how much he wished he could be with us and participate in it, but that he was actually going to be involved in defending certain prisoners' rights through our judicial oversight of prisons. And that is the ilk of the person that we have next speaking to us. Alok, with great, again, appreciation, admiration, I hand over to you.
Thank you so much. Thank you so much, Professor Meyersfeld. That was a very kind introduction, and I'm really grateful for that. I'm very excited. I'm very, very excited to be on this panel. And I'm really particularly very excited because, as you said, you know, when I was making my own migration, or I made my own kind of transition from human rights to animal rights, I was gifted a book, Rattling the Cage by Professor Owais. And that single book changed my entire, I mean, it changed my life, actually. So I'm actually really like a little bit nervous because I'm on the same panel with Professor Owais. So I'm pretty excited, but so, you know, it's really, I mean, you're probably one of the main reasons I'm doing this work. And so I'm really, really excited. And I'm also really excited because I'm excited this is a South-South dialogue. You know, I'm excited that I'm talking with colleagues from Chile, South Africa, and Pakistan, which signals that animal rights is a global movement. And with exemplary work coming out from the global South. And I think it's a really important thing for us to recognize. I understand the larger sort of, our panel today's title, Uncaging the Zoos. But my work in India is focused on captive elephants. And Indian captive elephants, or the captivity of Indian elephants, is sort of handled in a very different political economy. So we have to sort of reimagine the idea of zoo in our minds. Because, and I'll take you through that, but I'm really going to be talking about this very unique phenomena in India, where an elephant, a wild animal, is allowed to be privately owned by a private citizen as property, as cattle. The focus of my work, my larger work, like with most of you, is to question the moral basis of treating animals as property. It is with this intended critique I wish to lay out the self-contradictory administrative policy in India that allows elephants to be held with the highest protection and also captive and owned by private individuals, both at the same time. As a lawyer and an activist, I think it apposite to begin with the story of one of my own clients, an elephant who was known to humans as Lakshmi Kumari. Lakshmi Kumari, an Asian elephant, was born in 1950, the year the Indian Constitution was enacted, far away in the eastern islands of Andaman and Nicobar, where she began her life as a captive elephant used for timber logging. Over the last 7 decades of her lifespan, Lakshmi Kumari was taken from Andamans at the age of 50 to Kerala in South India to work in the temples, and then moved to the state of Goa, where I live now, in her 60s, to entertain tourists, always finding herself in the hands of a new human private owner, where she died last year during the first wave of COVID lockdown, having only known a lifetime of captivity. And of course, Lakshmi's story has had a deep imprint on my work and my life. But how and why was Lakshmi Kumari allowed to be held captive for 7 decades, despite the legal protection the Indian law offers? I call it the captive elephant exception in Indian law. Therefore, even though it is completely illegal to capture an elephant from the wild, it is okay and permissible in law to own an elephant and also trade, quote unquote, and use it almost like cattle. All elephants in India are protected under the Indian Wildlife Act through its highest schedule, which is Schedule 1, which is the highest protection any animal in India can have. Any capture of elephants from the wild to their natural home is illegal, as I said. Despite this, in the year 2021, we have close to 2,700 captive elephants in India, one of the highest numbers in the world. Elephant captivity is managed through an archaic system of mahouts, as the human trainers, caregivers, and handlers all in one person of the captive elephant. This relationship, which is at the heart or the center of elephant captivity, makes both the captive elephant and the mahout into victims, both serving someone else's private commercial interests. The changing perception of elephant captivity as cruel and dangerous has led to their use in timber logging, circuses, joyrides, and other forms of entertainment to be either banned, restricted, or on the decline. I recognize these as great victories of the animal rights movement in India. However, a disproportionate number of captive elephants, as many as 1,800 today, remain in the hands of private individuals as their personal property. These elephants are largely used as temple elephants and for traditional religious ceremonies and processions. How is this happening? A decade-old provision, Section 40 of the Wildlife Protection Act of India, which was meant to regularize the welfare of captive elephants at the time the law came into force, is being misused till today to transfer elephants from the wild into the hands of private owners. The intention of the procedure to obtain an ownership certificate was not to facilitate further ownership of elephants. However, it has become a loophole for precisely that. Therefore, when an animal with the highest protection guaranteed under Indian law can be subjected to ownership and consequently a lifetime of slavery and treated as a tradable commodity despite the protection the law offers, what does it say about our relationship with animals? I will focus on two aspects that help me understand and explain this administrative loophole and why it's allowed to continue. One is an administrative bureaucratic control over all wildlife, the forest. And second, a deep religious belief, both of which work in tandem to maintain the status quo of the captive elephant exception. Somewhere between the bureaucratic policy of regulation and the Hindu worship of elephants as demigods lies a deeply embedded belief to control and use the elephant. This control is exercised by inflicting extreme violence on the animal. Our collective activism has to challenge the dominion over elephants, often disguised as protection, and sometimes as compassion and reverence. But before I come to these two beliefs, these two systems of thought, I want to discuss a few cases just to show you, give you an idea what the Indian courts have been doing in helping captive elephants. I'll discuss three cases where, three recent cases where captive elephants, because of a High Court order intervention, have been released from their lifetime of slavery by applying the best interest child rights doctrine of parens patriae to elephants in distress. That's a limited role the courts have played in India, but they've done it consistently and very effectively. The first case that is very notable is a 2014 case of the Bombay High Court, which was filed by PETA. And it concerns an elephant called Sundar, who was 20 years old at that time. Sundar was born a free elephant in the forest of Assam, circa 2001 in the northeast of India in the forests. He was illegally captured, probably as a young calf, and ownership was granted by the forest department to one Mr. Maran. Now, this is a very unique phenomena, and I want to explain this because it's taken me a long time to get my head around this also. So if Mr. Maran, who owns Mr. Sundar the elephant, actually went to the forest to capture Sundar, he would be arrested. But if Mr. Maran gets up in the morning, and I'm sorry if this analogy sounds a little absurd, but it is an absurd situation. It requires an absurd analogy. But Mr. Maran wakes up in the morning and calls the forest department saying, hey, there's an elephant in my backyard and he's listening to all my commands. Can I own it? So the forest department will give you an ownership certificate. I mean, it doesn't happen that easily anymore, but until 10 years ago, that's exactly how it happened. So Sundar was probably born as a calf and ownership was granted by the forest department to one Mr. Maran. Mr. Maran gifted Sundar in the infamous Sonpur Mela, a cattle trade fair in Bihar in central India, to one Ram Naresh Singh, another individual, who was clearly an elephant trader, a very common trade among many people, who further gifted elephant Sundar to a temple in the western state of Maharashtra, where Bombay is, in a city called Kolhapur. This was done, by this time, Sundar was already around 8 to 10 years old. Sundar sadly represents the classic story of capture, ownership, sale, transfer, and further trade of a captive elephant. Like many elephants, he was tied up 24/7 in a small, tiny concrete block for years and was only controlled by a language of pain and violence. Based on an incredible campaign by Peter, following a court case in the Bombay High Court, Sundar was transferred to a sanctuary. The court assumed the role of a parens patriae. In the dispute between animal activists and temple owners, the court recognized the best interest of a highly cognitive and intelligent animal was best served by transferring him to a sanctuary. That was the limited role the court played, and that was done. The next case I want to refer to is a case from the Madras High Court in South India. This is from 2019, December 2019. Again, a very short order. Here, now this is, I'm also just sort of demonstrating how the kind of role the courts have been playing. Here, the Madras High Court played a role Indian courts play very often, which is a final call, a quasi-administrative, quasi-judicial authority. The case, like most animal abuse cases in India, begins with activist complaints, followed by inspections by court-appointed experts. And often, if not always, the court will enact the expert recommendation on its own order eventually to facilitate relief for that particular animal. In this case, the elephant was called Gomati. Without any fanfare or far-reaching ruling, the court had appointed Mr. Ajay Desai, now deceased famous Indian elephant scientist, to conduct an inspection of the elephant it received a complaint of. And this is what his report read. With the exception of the morning and evening walk, 3 to 4 kilometers, Gomati has been tethered with a short chain which allows only a few feet of movement and no activity for 57 long years. For an intelligent, wide-ranging and highly social animal, this would possibly be the worst punishment. This is the report. Like a life imprisonment in solitary confinement, Gomati was sent to an elephant care facility. The third case, which is a slightly, almost a hilarious case, so there's a notorious practice, but it's actually really on the decline, where most Indian cities and most people growing up in India, largely in South India, but also in other parts of India, we've all grown up watching these guys who bring these elephants to the streets who are called the begging elephants. So a man is dressed in the garb of a sadhu or a saint, and the elephant is a sort of semi-god representative, and he's going from house to house to collect some money. This practice has been cracked down by the Forest Department in a big way, and it's come down a lot. Sorry, David, I'll share the cases. Sorry, I'll share the cases.
Yes, I'll definitely
I'll do it.
ask that in a moment.
So now this is really interesting because, so the Forest Department, again, activists filed complaint saying Lakshmi, again, Lakshmi is a very common name for female elephants in India. So there are many Lakshmis that appear in my presentation. This is Lakshmi number 2. There's a huge campaign that was led by many activists in Delhi to free Lakshmi from the hands of the owners and from begging and to be relocated to a sanctuary. When the Forest Department finally passed an order to seize Lakshmi, the next morning, all of Delhi woke up with a big headline on the front page that Lakshmi has gone missing. Basically, the Mahout took Lakshmi, a full-size elephant, and went into hiding somewhere in the middle of the metropolitan city, the capital of India. And there's a huge search for Lakshmi. And Lakshmi was finally found. And I'm sure Professor Weiss knows this case already, but it's a very interesting case to interest you. So what happens is, Lakshmi is found and seized. And this Mahout, the elephant caretaker, finds a lawyer, a small lawyer. He has a very small little budget. And he files a habeas claim in the Delhi High Court, saying that Lakshmi is mine and I can't live without her. I love her. Please return her to me. And it's really fascinating. And the court rejects the claim. The court says Lakshmi's life belongs only in, I'll read out what the court says. These are not profound rulings, but they're really useful orders. Even if the
Alok, I'm
mahout,
just going to bring to your attention, unhappily, that you've got about 5 minutes left,
oh my
just
God,
so
okay.
that you're aware.
Okay, sorry. Okay. Even if the mahout is able to establish ownership, it would not be a ground to treat the elephant as his slave and move Elephant Lakshmi to an uncomfortable environment against her rights and interests. Consequently, the interest of Elephant Lakshmi is best served in a forest rather than in a congested city with a mahout. In my limited research, I have found over 50 cases across Indian high courts where courts have repeatedly intervened, always positively, in varying degrees to protect the interest of elephants, from stopping their transport in hot weather, in banning use of metal hooks, in declaring their use in circuses, joyrides, and begging illegal. However, we are still dealing with 1,800 privately held elephants, a total of 2,700 in captivity. The courts cannot individually be expected to help each and every elephant. But the one area that remains completely unchallenged is the use for religious ceremonies and temples. I'll just skip one section because I don't have time. A challenge to the entire policy of temple elephant use and ownership is a challenge to the deeply held religious and cultural beliefs. 1,800 elephants today are in one way or another used with temple or religious activities. That is our biggest challenge. And let me illustrate one example, one recent example of another elephant called Lakshmi, Lakshmi number 3, which illustrates the backlash, the fear of the backlash. Lakshmi, a temple elephant from Pondicherry in the southern state of in South India, was again directed by the Forest Department to be removed from the temple based on multiple documented complaints of abuse. This is from 2020. But Lakshmi was also deeply loved and revered by the people of Pondicherry, who refused to believe that she was being mistreated. Her temporary relocation to a health camp in 2020 sparked an outcry with the opposition demanding the resignation of the chief minister of the state. Lakshmi was returned to the temple. The chief minister himself passed an order. But I want to just I'm just going to read 2 paras and I'm done, Bonnie. Sorry. I'm sorry about that.
Please do so. No. Look, I think we're all riveted. So no. It's one of those awful parts of a conference. Take a few more minutes and please do tell us.
Thank you so much. In a rather unconventional order passed by the chief minister, citing not the suffering of Lakshmi, but the religious sentiments of the people, she was returned to the temple. Her rescue now depends on a pending appeal in the High Court, as she stands weaponized by the Hindu right for political gains. This is not the first time a captive elephant rescue has been politicized, and I fear it won't be the last. In a nationalist, borderline fascist political regime, animals are being used to consolidate a narrative of a Hindu India versus the other. Therefore, our love for animals must be expressed in concurrence with loyalty and adherence to religion and culture, and not in opposition to it. In the Hindutva ideology, the lines between compassion and exploitation of animals are deeply blurred. For example, while they are opposed to cow slaughter, they have no objection to dairy. Thus, religious compassion may forbid killing, but it will force Brahmanical vegetarian codes. It does not critique the exploitation of animals in their lived lives. It is therefore the lives of captive elephants spanning through decades of exploitation that are particularly heart-wrenching. Here lies the crux of the political challenge ahead of us. How do we create an incremental doctrine that chips away at the cultural argument by strengthening the interest of the elephant to the extent that the ownership itself becomes untenable? I'll just end here. Sorry, I won't further. Thanks so much.
Alok, thank you. And some comments in the box saying, can we get the unfinished talks in writing? I think that there'll obviously be an opportunity in the question and answer session, but it is an awful part of being a chair. And I am sorry, but that was
I'm sorry. I practiced twice to finish in 20 minutes, but I think I got carried away. I'm sorry. I apologize. Yeah.
No, I mean that's what we want to hear. You want to have these discussions. But what I want to mention something that struck me in what you've said, and that is about the context. You began by talking about the fact that there's a global South composition here, that actually has not been at the forefront often of work around animal law. And a lot of that is because there's this contestation between the socioeconomic realities of certain countries in the global south versus a sense that issues relating to animals is somehow the reserve of the privileged. And I had the most extraordinary opportunity recently to speak to a man by the name of Chief Stephen Fritz, who is one of the leaders of a group in South Africa known as the Khoisan, the original occupiers and peoples, the first peoples really of our country, who have been marginalized in so many ways. And he spoke about the importance of elephants to him personally, to his children, and to the Khoisan people. And he said most poignantly, when an elephant is in captivity, I am in captivity. When an elephant is in captivity, I cannot pass my culture to my children. And when an elephant is in captivity, the Khoisan people suffer. Without overly directing you, Macarena, I would like to introduce you now off the back of the sense that in the countries from which we hail, there really is a sense of hierarchy around urgent issues that need to be addressed, and that animals somehow falls to the back of it. And Macarena, I want to lead in her introduction by referencing the fact that she has written a book entitled Animal Law in Chile. And I can imagine that that must have been a labor of extraordinary love, coming from a person who could, by all accounts, have engaged in any manner of law, but has instead pursued a master's degree in animal law, a master's degree in European law from the Autonomous University of Barcelona. She has been awarded a scholarship as a researcher in training by the Catalan Agency for the Management of University and Research Grants. She's currently working on her PhD dissertation on non-human animal personhood at the Universitat Pompeu Fabra's law department. Incredibly, she's a visiting researcher at the Max Planck Institute for Comparative Public Law and International Law in Heidelberg, which is probably one of the most respected research institutions in the world, but also probably one of the more conservative ones. And to have someone like Macarena present in that environment to push away the boundaries of this notion of a hierarchy of issues and rights and the seriousness of laws is of great comfort to so many of us. As a member of the editorial committee of the Chilean Journal of Animal Law and a treasurer of the Great Ape Project, is an extraordinary privilege and pleasure to have you with us. And I hand over to you, Macarena.
Thank you, Bonnie, for that really kind introduction. I'm going to share a presentation. Can you hear me okay? Everything's working, right? Okay. So, well, good afternoon to everybody. I'm really grateful for this invitation and for getting to know some incredible speakers from different parts of the world. And I also am grateful to everybody that's connected here today, participating in this seminar on animal rights litigation. My presentation is based on a paper I wrote, which provides a systematic historical overview of case law from different countries on non-human animal legal personhood. Today, I will be focusing on the Latin American cases, but due to the time limit, I will only mention the most important cases as well as the findings and conclusions of my research. Oops. There. Okay. Most of the Latin American cases are habeas corpus cases that seek to attribute basic rights like the right to bodily liberty to an animal. These cases have taken place in Brazil, Argentina, Ecuador, and Colombia. The pioneer case took place in 1972 when an animal rights NGO filed a writ of habeas corpus on behalf of all imprisoned birds that were sold, used, hunted, or poached in Brazil, requesting their freedom of flight. The court rejected this case, arguing that the habeas corpus could only be filed on behalf of a human. Some scholars have interpreted this pioneer case as a metaphor directed against the dictatorship of Humberto de Alencar Castelo Branco, who ruled Brazil between 1964 and 1985, rather than as a genuine attempt to obtain the recognition of birds' right to freedom. After this case, between 2005 and 2010, there were some habeas corpus filed in Brazil on behalf of chimpanzees. The most important case was Suiza's case. Suiza lived alone in a zoo in Salvador. Two public prosecutors filed a writ of habeas corpus on her behalf, requesting the court to order Suiza's transfer to a sanctuary. The judge, Edmundo Lucio da Cruz, admitted the habeas corpus and granted the Department of Biodiversity, that is the governmental agency in charge of the zoo, 72 hours to present its arguments. This governmental agency requested for a second 72-hour extension, which was granted by the judge. But unfortunately, the day the court was supposed to decide this case, the government, the zoo, informed that Suiza had died the day before. And the judge then was forced to dismiss the case. And in his judgment, he said that he was very surprised with this because he had visited Suiza the week before and she seemed to be doing okay. The fact is that Suiza was killed and her killers were never found and her death wasn't investigated. Even though this case ended tragically, Suiza's case is remembered as the first time a court recognized an animal as a subject that could claim her rights in court. And it has encouraged the debate on animal legal personhood in Brazil and the rest of Latin America. Jimmy's case is another habeas corpus presented in Brazil that shows a certain evolution in the judge's attitude towards these types of cases. Jimmy was forced to perform in a circus for many years and was then donated to a zoo. In the zoo, Jimmy lived alone and became famous because he enjoyed painting. The Great Ape Project filed a habeas corpus, which was rejected by the courts because it did not deem Jimmy to be human. However, the judges debated the case for more than 3 hours, which was interpreted as a sign of doubt among them. And at the same time, the Great Ape Project informed the governmental agency in charge of the zoo, IBAMA, about the deplorable conditions of this zoo. So the zoo was finally closed and the animals were seized. And as a result, Jimmy was transferred to the Sorocaba Great Ape Sanctuary in Brazil. So although the judges denied the habeas corpus in this case, Jimmy was finally transferred to a sanctuary thanks to a parallel administrative procedure initiated against the zoo, which ended with its closure. So in this sense, we can see that administrative procedures can be useful backups for habeas corpus in case these procedures fail. So, since 2013, several habeas corpus were filed on behalf of animals in different Argentinian cities. The majority were filed on behalf of chimps, but a habeas corpus was also filed on behalf of Arturo, the polar bear, internationally known as the saddest animal on Earth, and on behalf of Sandra, the orangutan, who was recognized as a non-human person by some judges of the Federal Criminal Cassation Court, one of the highest courts in the country, although she was finally transferred to a sanctuary thanks to another type of procedure, not the initial habeas corpus. Let's say that the first legally successful habeas corpus case took place in Argentina in 2016. Cecilia, the chimp that you can see in the photo, was recognized as a non-human person and granted the habeas corpus. Cecilia has been living in Brazil's Great Ape Sanctuary since April 2017. And this case was easier than most cases because finally all the parties, the zoo, the government, and the NGO agreed to send Cecilia to a sanctuary. And this picture that you can see, this photograph of Cecilia, is like a really symbolic photograph because it was taken the first night that she arrived to the sanctuary. So you could see that she's appreciating her new home and enjoying her first night there. So now I'm going to talk about the case of Chucho, the Andean bear. So Chucho and Clarita, his sister, lived together in a natural reserve and semi-captivity for most of their lives. Clarita died from cancer in 2008 and Chucho became severely depressed. Therefore, Corpo Caldas, the environmental authority of that region in Colombia, decided to transfer Chucho to the Barranquilla Zoo in June 2017. Therefore, a local lawyer filed a habeas corpus arguing that Chucho had the right to return to his natural habitat. Here it's important to understand that Andean bear's natural habitat is the Andes Mountains. So high altitude, it's cold and very rainy. And Barranquilla is a Caribbean city, so it's scorching hot all year round. The Civil Family Chamber of the Superior Court of Manizales denied the petition. So this was appealed to the Civil Chamber of the Supreme Court of Justice, that is one of the highest courts in Colombia. The judge, Luis Armando Tolosa, overruled the judgment and granted the habeas corpus on July 26, 2017. But the zoo wasn't ready to lose the fight. So the zoo presented a tutela, that's a type of action in Colombia that seeks to protect other fundamental rights. And it presented this action to the Labor Chamber of the Supreme Court of Justice. The court granted the tutela and agreed with the zoo that the habeas corpus violated the zoo's right, such as the right to a due process. So the decision was appealed to the Criminal Chamber of the Supreme Court of Justice, which also confirmed the decision. Oops, sorry. After this, the Constitutional Court selected this case for revision. This court has the faculty of revising tutela judgments. The Constitutional Court judges insisted on the selection of the case for its novelty and for the opportunity to expand its jurisprudence on animal rights. In January 2018, Judge Fajardo, that you can see in the photograph, was designated as the judge in charge of Chucho's case. And she asked for expert opinions on the case as soon as she received it and organized a hearing, which was held on August 8, 2019, where various experts in animal rights and animal ethics were heard, such as Paula Casal, the Spanish philosopher and president of the Spanish Grade 8 Project, and Stephen Owais, who we just had the pleasure of hearing. At the end of January 2020, the Constitutional Court rendered its verdict. The court decided to confirm the tutela judgment, that is, it denied the habeas corpus. According to the court, the habeas corpus is not the appropriate mechanism to resolve an animal welfare dispute, because the writ seeks to protect persons' right to freedom, and the court mentioned that there are other mechanisms to protect animals. The judges also stated that animals are not subjects of rights in Colombia, but rather sentient beings. However, Judge Fajardo had proposed a ruling that granted Chucho the habeas corpus and recognized him as a legal person entitled to freedom. This proposal was supported by only 2 of the 9 judges in the Constitutional Court. Judge Fajardo has criticized the Constitutional Court for remaining stuck in a formalist approach of the law without building effective mechanisms to protect animals. Despite the dismissal, Chucho's has been a historic case, not only because a higher court granted a habeas corpus to an Andean bear, but also because this debate has elicited contradictory opinions on legal personhood and animal rights from different chambers of the Supreme Court of Justice and among the Constitutional Court's judges. Normally, such cases are dismissed at the lower court level, but Chucho's case reached 2 of the 3 highest courts in the country. Even though the Constitutional Court denied the habeas corpus, its active and serious role has been quite unique at a global level. This court had no obligation to review the case, especially considering that it would have to review the judgment of one of the other highest courts in the country, the Supreme Court of Justice. Additionally, Judge Fajardo asked for reports from experts on animal rights as soon as she received the case. She then held a hearing and invited many experts, not only from Colombia, but from other countries. And she was flexible and accepted the intervention of people that lived abroad through videos. And it is important to note that the Constitutional Court is not required to hold a hearing during the review of a tutela, but nonetheless, Judge Fajardo considered experts' interventions on animal rights essential before deciding the case. So in sum, we need more judges like Judge Fajardo to protect animals effectively in Latin America. After reviewing many cases, the first thing that pops up is that even though initially these cases were considered as ridiculous or as having low chances of success by some people, attempts to accord legal personhood to animals have exhibited an increase in number, as well as in the variety of species and countries involved, and their ability to reach higher courts. As my research shows, legal personhood for animals has come a long way. Initially, there was 1 case a year at the most, usually regarding a chimpanzee. But during the last decade, we have seen several a year regarding different species. As the frequency of cases has increased, the attitude of judges has also begun to change. The opinion that these lawsuits are ridiculous has been replaced by longer deliberations at higher courts, as Jimmy, Sandra, and Chucho's cases show. Moreover, courts have started to recognize that they can no longer simply dismiss a habeas corpus because the animal is not human, considering social pressure and the evolution of case law on animal protection. Reflecting on the development of the cases, dismissal strictly based on membership to the human species was not the main trend. In most cases, courts examine legal personhood. However, there are still some courts that prefer to dismiss these types of cases on procedural grounds. Additionally, the success of such cases does not depend mainly on the animal species, genetic closeness to humans, or cognitive abilities, but instead on other factors such as strategy, the technical aspects of habeas corpus, and the judge's empathy towards animals, willingness to hear a novel case, and general philosophical outlook on law. If such cases strictly depended on cognitive abilities or genetic closeness, then chimps would be the most successful species in courts. But in fact, only 1 chimp case has been successful. The other cases that were granted by a court but later reversed involve an orangutan, the great ape that is genetically most distant from humans, and an Andean bear. Finally, 3 dilemmas were revealed. The first concerns the pros and cons of employing legal versus political means. The second concerns the relative advantages of habeas corpus versus other legal strategies. And the third concerns whether legal practitioners should attempt certain cases with a very low probability of success. In some of the examined cases, judges have argued that a petition to recognize animals as legal persons should be made to Congress and not the judiciary, as occurred in Chucho's case. We probably all agree that the purpose of these lawsuits is to make things better for animals, not worse. However, there is a dilemma when deciding whether to fight for animal personhood in court. A case with a high chance of success could lead to the animal in question being killed, as occurred in Suiza's case. The political struggle for a bill on animal personhood does not face this dilemma because a bill would not target an individual animal, but 1 or more species instead. However, the fact that several animals have died during these lawsuits, such as Suiza, or a couple of years after the case ended, such as Arturo, the polar bear, shows that these cases are truly urgent. All these animals have suffered greatly from physical and psychological illness due to captivity and isolation. Therefore, in most cases, there's no time to start a political process in Congress. Political strategies for animal personhood might be a good option in the long run, but they may not be enough to help animals that are currently suffering the consequences of captivity. Furthermore, seeking a bill on animal personhood is not only a slow endeavor, but a difficult one due to all the lobbies that would oppose it. Hence, animal rights advocates are forced to seek help from courts, and mainly do so through habeas corpus. Some might argue that all the judicial defeats prove that this option is even harder than the political endeavor. However, judges have started to accept habeas corpus as an adequate legal action because there are no other available mechanisms for requesting the animal's freedom, and judges are required to solve the case, as Cecilia's case demonstrates, as well as Judge Fajardo's dissenting vote in Chucho's case shows.
Macarena, I'm really sorry, I'm going to have to ask you to wrap up.
Yeah,
again, one of the worst parts of this job.
No, don't worry.
Please do carry on.
5 minutes and I'm done. Do I have 5 minutes?
Go for it, absolutely.
Okay, so the second dilemma is that animal rights advocates must consider that some courts confuse the terms human and person and use them as synonyms, as Judge Rojas' dissenting vote in Chucho's case highlighted. Moreover, some judges and attorneys seem to fear the effects that the judgment might cause in other activities that use animals, rather than focusing on the specific animal plaintiff, as Chucho's hearing proves. Therefore, this judicial fear affects the animal plaintiff's chances of being recognized as a legal person with their certain basic rights, because the judges are thinking about other animals and other activities. Even if it were true that the habeas corpus presents this peculiar difficulty, it is not the only mechanism to argue for an animal's legal personhood in court. For instance, I found 2 animal cruelty cases in which the judges recognized dogs' legal personhood on their own motion to stress how much the animal has suffered and the seriousness of the offense. So it is positive to have different strategies to seek the recognition of animals' rights. And finally, the third dilemma is that attempts to obtain legal rights for animals were considered unlikely to succeed initially, and probably any attorney can agree that there are some legal strategies that have a greater risk of creating negative precedent than others. The point of contention is how animal advocates should act in view of those types of cases that have a very low probability of success. Should they go ahead with these cases? And I believe that going ahead despite the low probability of success has had several beneficial consequences. For example, fragments of judgments that were inconsequential or unsuccessful can be exported to other cases with a positive effect. For example, obiter dictum declarations and judgments can influence other national or international judgments. In fact, the Federal Criminal Cassation Court's judgment in Sandra's case inspired the judge in Cecilia's case, and Sandra's judgment that was overturned is still quoted as an exemplary case around the world. For example, it was mentioned in the judgment of the case involving the Marghazar Zoo in Islamabad. Second, partly because of this, animal legal personhood has become increasingly supported by judges, attorneys, renowned scholars, and scientists from around the world, showing that these cases are neither ridiculous nor frivolous, which normalizes the topic among the public. And third, impact on the media and the public's growing familiarity with the possibility of animal personhood, as well as the general public's emotional involvement with specific individuals like Sandra, Cecilia, and Chucho, mobilizes courts and governments to act. And so this is the end of my presentation. This is my email, and if in case anyone wants to contact me, thank you for your attention.
Macarena, that was just so compelling. And again, I'm so sorry to have had to interrupt you, and I do apologize. The common theme that came from your talk that resonated so much with me is the banality of the law, that sometimes it's your unexciting and very drab administrative law, basic principles, black letter law. Throughout all of these talks, we've heard this formalistic approach that Judge Marizado commented on. And in a way, what we need is some creative lawyering to understand that as lawyers, the presentation of the arguments that we make in respect of animal well-being and within the realm of these very crude and constrained legal categories is something we must never stop doing. And especially in light of the fact that the law is a sloth and moves at a pace that is at odds with the urgency in which animals find themselves. And really, it's on that basis that I think I'm really excited to introduce Owais Awan, who has indeed utilized some of that advocacy and some of that creative lawyering, as all the other panelists have. Owais is probably most well known for being the lead counsel on the recent case before the Islamabad High Court on the release of Awan, the Asian elephant in Islamabad Zoo. And it's one of the most successful cases. Stephen, when you began your talk, for those of you who weren't with us at that point, mentioned that he's been litigating these issues for 8 years, and Owais litigated one and has won. And you've really inspired us all, Owais, with your work. And it's not only about winning the case. Owais has also been involved in the relocation of Awan and others to appropriate sanctuaries in various parts of the world. Given our shortage of time, I'm not going to say more about Owais's very extraordinary CV, other than to say that Owais is committed not only to the Pro-Elephant Network, which is a member PREN, but also to the issue of humane stray dog population control. And some of you may be aware that at the end of the genocide in Rwanda, the only thing that the United Nations did was come in and kill all of the stray dogs. And there's a poignant revelation into the lack of humanity and sensitivity of a lot of our species in that was the step taken in the wake of the genocide. But on that note, let me introduce you and hand over to Owais. We so look forward to hearing from you.
Hello, everyone. I hope I'm audible. Firstly, thank you so much, Amy, Professor David, for having me. And it's such an honor to be in an esteemed panel like this. And coming to Professor Stephen Wise, I want to say it from the very beginning that Professor Stephen Wise is a legend in this field. Whoever is interested in animal rights knows the importance of the arguments which and the notion of non-human animals, which is advocated by Professor Stephen Wise, is absolutely incredible. And I feel he's way ahead of his time. And I have absolutely no doubt that one day or the other, his unique approach of habeas corpuses would be recognized, and it would be normalized, like Macarena just before me said. So and you know, I was not the lead of the case. I think I played a small part in it. It was was a collective effort to get the judgment and relocate Kavan, and it was a result of collective conscience, I feel. So, but I'm thankful for your kind words. So, a little introduction, what the kind of cases that I'm doing right now and what I've done, other than Kavan, was that we've been able to relocate the 2 Himalayan bears in Islamabad Zoo to a species appropriate sanctuary in Jordan. I'm working on the stray dog population control issue in the federal capital, Islamabad. And I've also filed a petition in Karachi for the 4 Karachi elephants. It's along with Pakistan Animal Welfare Society. And we've also filed a petition for the regulation of the trade of falcons, the export of falcons from Pakistan. So, to be honest, I wasn't one of those lawyers who had it planned that he will get into animal welfare, animal law, animal rights. But it just so happened that when I started researching and a legal proposition came, I realized there was next to no jurisprudence, and we just took the initiative. So, as everyone would have noticed that, recently there has been an influx of cases all around the world regarding non-human animals, and we can clearly see that interest of people has increased. It has become a very, interesting debate, and it is almost part of the discourse, normal discourse now. See, if seen in context, the way I see it is that in mankind, like slavery was abolished, which led to the civil rights movement. Now, animal rights is one thing which soon will be on the policy agenda globally. Regarding the legal arguments that we've been able to take in Pakistan, I think in South Asia, habeas corpuses have not been accepted as such jurisprudentially, and the accepted norm, which is the writ of mandamus, or we can also say the public interest petition, both in India and Pakistan, which the courts have been more receptive towards. In Pakistan, for me, the whole Kavan experience was very personal and emotional, because elephants, Asian elephants, were very much part of the ethos, heritage, and history of Pakistan. But somewhere down the line, they became extinct. And Kavan too, although he was an Asian elephant, but Kavan was a diplomatic gift by the government of Sri Lanka to the government of Pakistan. So there was a little question of international law involved in the case as well, that whether Kavan should go back to Sri Lanka or not, because diplomatically it might not have been well received to send back Kavan back to Sri Lanka. So these were the aspects of the cases which happened. And coming to the arguments which have been acceptable in Pakistan, the notion of right to life has been a very important component of environmental jurisprudence. This environmental jurisprudence has grown in more of a climate change perspective, but there's definitely animal rights and nature which has a close connection with each other. I'm going to come to personhood later, but the idea of life has been interpreted very liberally by the Pakistani courts. Life does not mean a vegetative state of being, but life includes all facets of human existence. And to understand animal rights, the most basic level approach would be the human-centric approach. That we say that we have to look after our animals for our own sake. because our own interest and our own welfare is dependent on them. So, and then comes the very advanced level argument, which Professor Stephen Wise is taking regarding bodily liberty and recognizing the personhood of animal. I think we are not there as yet, but soon it appears that Pakistan will be accepting, sooner or later, will be accepting that argument as well. So that is what I want to talk about was the contrary point of view, because we're focusing on captive animals over here. The counter arguments that we have faced is they might have substance. Firstly, the great debate of welfarism and abolitionism. We were lucky that the court, which is very rare, that the court was, one could say, an abolitionist, that the court did not believe in having a zoo. Zoos, as we know, have a grim history, and a grim and a dark history behind it. How zoos became in existence. Initially, there were human freak shows, there were circuses that led to captivity of humans, of different indigenous kind of people, and then animals. So the question really arises whether zoos have become an outdated concept in 21st century. Do we really even need zoos? That is one big level argument that against release of captive animals. So, and then zoos authorities throughout the world, we will see, are understood in a very commercial context. The zoo would be in a very prime location, in prime property, and all of the focus of the management would be on profiting from these animals. So the welfarism debate and the abolitionism debate. The welfarism debate, the perspective does have substance in it as well, because that narrative really says that, okay, it's a very practical approach. It says, okay, we might not be able to get the utopian concept that, okay, that there should be no zoos, but at least we can improve their living conditions while they are there. We can provide them with better housing facilities, housing conditions. So this is one of the dilemmas that I have faced as a practitioner, as an advocate. So that is one. The second is religious principles on animal rights are very interesting. We did take arguments from Islamic principles to support our case, and we were surprised on how Islam really recognizes animal rights and animal welfare and the personhood of animals. There were several references in the Holy Quran and the sayings of Holy Prophet, which clearly and categorically recognized animal welfare. But the biggest dilemma that I've faced by far right now is the speciesism debate. I think we still haven't been able to figure out that what's the level of rights that we are talking about. Which animals get what kind of rights? It appears that some animals are more equal than others. Like, to be brutally honest, Awan had a big fan base. He was loved locally as well as internationally. But the same kind of interest or affection would not be for, let's say, chicken or ungulates, although they are also sentient beings. So this, for me, has not been clear how the animal rights jurisprudence will develop, considering that if there's going to be preference to certain kind of species, then obviously the speciesism would have to be accepted as a fact, as an honest, brutal fact. One of the things that I really wanted to talk about was that zoos authorities are also against release of animals because they see it as a matter of national shame. They see it as a very bad marketing for them and bad image, which is why, at least in Carvin's case, at least, we did face a lot of resistance, and that's usually what we face in most of our cases, is that the authorities would say that we are trying to bring a bad image and bad name to the country. Although I obviously personally disagree with that. The judgment of Islamabad High Court, one could also say that it was a popular judgment. It was an abolitionist judgment, and Carvin and the Bears were definitely they had a great home. But some of the conservative lawyers, I would say, criticized the judgment, saying that it is not the duty of the courts to decide on these issues. Whether there should be a zoo or not is a policy issue, and that's not the domain of the courts. And especially in developing countries like Pakistan, animal welfare can also be seen as an elitist issue, where there are human rights crises. It is seen that people are unable to relate to the importance and significance of animal rights. So yeah, and at times there are no alternative places available. So if, let's say, in the case of Islamabad Zoo, the Islamabad Zoo has shut down and it's been converted into a wildlife conservation center. It's still in the process, but most of the animals, because there were no sanctuaries in Pakistan for many of the animals, so they had to be adjusted in different zoos and enclosures because there was lack of any sanctuaries specifically for them. Ideal remedies by the court, what I think would be ideal is, of course, release of animals to the sanctuaries, provided that the sanctuary is up to international standard. And courts can play a very big role in providing interim measures and interim reliefs. For instance, getting the medical assessment done, or providing immediate relief, such as getting bigger enclosures or improving the housing facilities. And sorry, and in Pakistan, at least, we can see that a floodgates kind of a situation has opened. There's been a massive increase in terms of litigation all around Pakistan after the Carvin's judgment. In Lahore right now, there's a very important petition on stray dog population control. In Karachi, like I said, there's on the 4 elephants. Recently, there was a petition on the Himalayan bear in Karachi Zoo. So again, in common law, the judge's perspective really does matter a lot. For instance, there's one petition pending in the Supreme Court of Pakistan, which is on the import of African elephants. So a private dealer has gone to the court against the government, against CITES, to be specific, that CITES is not issuing them an import permit to bring in 2 African elephants from Zimbabwe. Now the local CITES over here is obviously not issuing the permit because of the CITES regulation, which is that elephants cannot be used for commercial purposes. So but in that case, in at least the High Court, we saw that the court was inclined to bring in more elephants, and they thought that the public is missing out on a lot, and on not having elephants in terms of education and awareness. And zoos definitely take this one big argument that they are playing a role in conservation, which I mean, at least I would talk about the zoos I've been to. Some of the zoos, yes, we can say they do provide rehabilitation centers. They would conserve different kind of species, but many zoos are just for the sake of profiting from them.
Owais, I'm so sorry to rush you, but I must ask you to please wrap up as you can.
Of course, of course. But so in the end, I would just wrap up by saying that we can be cautiously optimistic that this jurisprudence will develop a lot in time, and more relief can be provided to our non-human fellows. And what I really love is the global community of animal rights that there is, and how one jurisdiction is citing cases of other jurisdictions, and it's they're complementing each other. So again, I would say I'm pretty positive, and thank you so much. I'll drop my email over here. Any questions, please feel free to ask.
Huge thanks. So I was really very grateful for that. And again, sorry to have to rush you. We have 15 minutes left in which to ask an array of burning questions. I'm going to suggest the following. I'm going to select a handful of questions and direct them to specific speakers with the hope that you would then please answer that question or address it and then make a final point or comment. I'm then going to invite the audience to please email us any questions that you have to specific speakers or to one another, and comments that you have, and we can try and make sure direct those questions to the various speakers to the extent that we'll have the ability to do so. One of the questions that arose was to Stephen, to Professor Owais. In fact, there are a few questions for you, but I'm going to select one that I think is particularly unique. Do you think that in the future there will be less resistance from the law and the judges to recognize personhood to artificial intelligence compared to the arguments used against animals having personhood? Many thanks for the amazing presentation, Steve. Cheers from your friend Carlos from Barcelona.
This sounds like Carlos Contreras trying to harass me here. Okay, that is it's not an easy question to answer. Judges had generally never been asked to recognize personhood, in artificial intelligence, but I suspect that if the kind of artificial intelligence that was in front of them allowed them to, required them to recognize them as persons, that it would be the very similar issues to the ones we're doing. I don't think it'd be any easier. I think it probably could be harder, but I'm not sure as to whether or not a court would give personhood to someone who's holding artificial intelligence as opposed to the intelligence of many non-human animals. So I really don't know the answer to that question.
It's a great question, and one that maybe we could all actually think about, given that it is a shift in mindset. So it's your best article, Steve.
I have indeed spoken to people about this actually for more than 20 years, and I think for me the most important part is that the degree of artificial intelligence that would allow personhood, I think, is very, very far away from us, and whether it would ever actually reach that point is an issue that I don't know.
Well, Carlos is very grateful for your answer, as are all of us. So the next question I'm going to put to Alok. Alok, do you think that judges are ever going to really understand that the reference to rights and duties as a corollary to rights is fundamentally flawed, because not all humans have the same duties and not all humans have the same rights. Children don't have a right to vote, and yet we don't deny them personhood or the basic other fundamental rights. So do you think there'll ever be an appropriate response from the judiciary that recognize the appropriateness of a rights-based understanding of animals, notwithstanding that their rights they won't be able to exercise, such as the right to free speech necessarily, although they might, that's a different discussion, but that we could change this fundamental prejudice?
Thank you, Bonnie. That's a really great question, and I think I want to connect 2-3 things here. I mean, I think Professor Weiss spoke about this in his presentation earlier, that about the judge who actually sort of came back and said that he's had a sort of a rethinking of the issue. In my own kind of research on Indian case law, I have been fascinated by just the incredible level, the extent of empathy and understanding of animal rights the judges have shown. So many of our animal rights cases have actually been entirely initiated by judges. There are often disputes that have become animal rights jurisprudence, where actually animal activists are not even litigants. And I think so. I think there is so much of our jurisprudence is obviously the presence of the right judge before us, obviously, right? And but on the issue of duty, actually, you're really giving me an opportunity to conclude my talk, because there's something really fantastic in the Indian Constitution, because the Indian Constitution, actually maybe one of the first constitutions in 1976, in the 42nd Amendment, added a chapter on fundamental duties. And one of the duties to all Indian citizens was to show compassion to living creatures. And it is sort of something that was sort of never really used, it never really became part of our jurisprudence, even though some other duties, there were 12 duties in total, would be discussed in different cases. But the famous Nagaraja case, which recognized that animals have a right to life, actually the Justice Radhakrishnan of the Supreme Court of India kind of added meaning to that idea of what that duty would be like. And he said that, you know, that duty actually requires us to treat animals as equals. I mean, maybe many Indian scholars argue he may have gone too far. But I actually think that there is an opportunity here for us in Indian jurisprudence, and maybe jurisprudence at large, to really define this idea of our duty towards animals, and to really trace that from constitutional principles. So I have actually been arguing that we need to create an idea of constitutional duties towards animals. And these are not duties that come out of some religious or traditional or cultural understanding of the fact that we are Indians and we come from a society of compassion, but they're actually entirely sourced from the values that our constitution is based on. So, and I think, I actually think that the scope of duties has a really great potential to expand the idea of animal rights. I know that you talked about this idea of, just to quickly conclude that, and I think most judges understand that the rights we're talking about animals are the rights that are concurrent with animals' natural behavior. And the most common natural behavior for the animals is to be free, is to be in their natural environment, is to live their life as per their natural instincts. So I think the idea of animal rights is very much confined to that. And I think, I think increasingly judges have that understanding. So I don't see a conflict that the extension of animal rights does not come with the duty of exercise of rights and responsibilities, which is a very human construct. I think there's enough scholarship that has actually helped us understand that we're talking about natural rights for animals. Anyway, thanks. Sorry, I kind of brought a bunch of things in here. Thanks.
Thanks so much, Alok. You know, I must say there's a rights violation going on and forcing me into a position where I have to keep you all to time limits and not less. This is just outrageous. I don't know who taught me into doing this dreadful job. Macarena, to you. The question is, why in Colombia did you manage to present habeas corpus application in favor of a bear without actually having gone through chimpanzees before, which generally tends to be the first animal high courts will be responsive to, obviously, given the closeness in genetics and obviously in one's imagination between these two species of great apes. So over to you, Macarena.
Thank you for the question. So I think that the attorney that filed the habeas corpus on behalf of Chucho in Colombia was pretty smart and strategic about the species of animal he chose, because the Andean bear is a protected species in Colombia, and it is the only species of bears that is native to Latin America that still exists. So there's the government in Colombia has a protection plan and strategy to protect Andean bears. And so in this case, we can see that environmental interests are in the same line with animal protection interests. And this was quite smart because none of the judges, not even the ones that denied the habeas corpus and the tutela, thought that it was strange to be asking for a habeas corpus on behalf of a bear. They didn't say that. They didn't talk about chimps, or the argument wasn't based on this. And this is because Colombia has like a very strong the protection of the environment and the Amazon and of their native species is really important in the country. And so this is probably why this attorney chose Andean bears instead of chimps or other species that are not native to Colombia.
I mean, I think that's also a really interesting insight into litigating alternative avenues. What is it linked to in terms of established and accepted principles, such as a protected species? Last, and of course, most definitely not least, Owais, there's a question here that was not directed to anybody in particular. I think there've been quite a few questions directed to you, which you've answered in the chats. But the question that I'd like to put to you is, do you think that there's a possibility of using the writs of mandamus for the purposes of an interim relief where animals are in distress? And it's quite an interesting idea that has been presented here, which is that legal status of animals needn't always be binary, a person or a thing. India has recognized animals as dignified beings, creating statutory duties on humans in charge of them. Would you say this is an adequate safeguard?
Yeah, sorry. So as a lawyer, your legal strategy really matters a lot. There's a saying that a good lawyer knows the law and a great lawyer knows the judge. But that doesn't mean that the lawyer knows the judge personally, but he should be able to understand what kind of ideology and perspective does the judge, does the court keep. Like I said in my talk, in South Asian context, in India and Pakistan, the most important case in South Asian jurisprudence would be the Nagaraja case. That too was in the form of mandamus. So, and when we say mandamus, it is that the public interest litigation, which high courts and the Supreme Courts of India and Pakistan have done. So, again, it is a question, academically, the personhood argument makes the most sense, filing a habeas corpus. But if you have to get the relief and get the job done and on ground, on field, help the animal, and for that sake, if a writ of mandamus works, then one should definitely use it to full effect.
Thank you very much. We really are coming up to the last 4 minutes of our seminar. There are, I think, no further particular questions. So perhaps you'll allow me, with indulgence, to conclude, and to conclude on the basis that at Animal Law Reform South Africa, our objective is to ensure that we combine into a seamless connectedness the notions of animal well-being, social justice, and environmental justice. Because for so long, society and our species has seen them as separate issues. The South African Constitution, quite uniquely, protects the right to an environment. And Section 4 of the Constitution says that everyone has the right to an environment, amongst others, that is protected for the benefit of present and future generations through reasonable legislative and other measures that promote conservation and secure ecologically sustainable development and use of natural resources while promoting justifiable economic and social development. And at the core of this is not only that there's an artificiality to seeing an elephant in a zoo, because there is no connection between that species and their well-being. But it's also because we're not seeing animals connected, we're not seeing an elephant in her or their natural habitat and interacting with other animals in that habitat and being responsive to the changing habitat. I think there's a rethinking entirely that needs to happen regarding the law, social justice, the environment in which we find ourselves, and the fact that at the core of all of that, interconnected, inextricably linked, is the well-being of non-human animals. I cannot thank you all enough for being here with us and listening to this. It has been extraordinary and far exceeded our expectations to hear these wonderful, wonderful speakers. And I'm just watching on the side of the chat, the most wonderful comments coming through saying thank you to all of you with profound respect for your work, with thanks for your time. And thank you for those who did attend. We've had an extraordinary turnout. And I'm really excited about the fact that there is a growing army of warriors who will be fighting for the justice in which we all obviously believe. And finally, a farewell and a thanks to Amy and David for the most wonderful people to be involved within this. Amy, thank you particularly for bringing this all together, and David. On that basis, I'll see you, David. Amy, do you want to say anything in conclusion?
Just to say thank you to everyone, and we look forward to engaging more ensuring more academic engagement with these fascinating developments. And of course, also please look out for more of our seminars on these topics and others, and the conference, of course, as well, which we'd love people to participate in as well.
Thank you, Matt.
Thank you,
Thanks
guys.
to all of you.
Thanks so much.
Goodbye.
Sorry. Bye, everybody. All the best. Bye-bye.